Occasionally, you will see somebody arraigned for drunk driving in district court, and the person just wants to admit to the crime right then and there and do a plea. In other words, just wrap his case up at the very first hearing. I'd say this happens maybe once a month or every other month. You'll see it happen in district court. Now, the judge can and often will go along with this, right? If the person was arrested that morning, say the person was arrested at 2 a.m. or 3 a.m., and the arraignment is at 9 or 10, the judge may not do it in those circumstances because the person might still be impaired. But if the arrest took place a day or two prior, the judge might allow the person to do a plea at arraignment. Now, there are advantages and disadvantages to doing this. Probably the biggest advantage, and the reason why most people do it, is to cut down on the license loss. Now, the way an OUI works here in Massachusetts, you are most often given the option of taking the breath test. Now, if you're 21 or older, and this is your first OUI, if you fail the test, you lose your license for 30 days. If you refuse the test, you lose your license for 180 days. In either case, this is an imminent threat suspension, and you cannot get a hardship license during that time. However, if you do a plea, you get typically a 45-day loss of license, which will supersede the imminent threat suspension. And you can apply for a hardship license during that time if you enroll in the impaired driver program, and you can convince the registry that you qualify for a hardship license. So by doing a plea at arraignment, you significantly lessen the impact of the license suspension and reduce the amount of time that your license will be suspended. Otherwise, you'll do the arraignment, you'll get a hearing in 60 days, so you'll lose your license for at least 30 days. Maybe you'll get it reinstated, costs $500. And if you do a plea later on, you then lose your license again for typically 45 days. All right? So in some ways, it makes sense. Right? Also, you spare yourself the burden and the anxiety of going to court every couple of months for possibly a year or more. And you don't have to pay for a lawyer and so forth. Now, the biggest disadvantage is that you lose all opportunity to defend yourself, to put up a defense. Now, in many cases, OUI cases or charges are defensible. All right, just because you took the breath test and it's 0.08 or higher doesn't necessarily mean that you're going to lose at trial or that you can't put up a good fight or get the breath test suppressed. But you don't know until you get all the discovery from the prosecutor. All right, you get the body cam videos, or the cruiser cam video and the booking video, and you scrutinize everything, right? Because there could be a defense in there that you're not aware of at the time of arraignment. So you're giving that up if you just walk in at arraignment and do a plea. All right? Also, if you do the plea, you essentially have a first offense OUI on your record, and if you get another OUI, a second offense OUI here in Massachusetts, the treatment is much more severe. Right? So there are good reasons to contest an OUI, or at least see if you can do that. Right? It takes several months of hearings to get there. Right? So I've written a blog post on this, and I will put it in the description below.